Thanks very much, Mr Deputy Speaker. Look, I, of course, like all my colleagues, support this legislation, but totally endorse the comments that have been made by our previous speakers that this is indeed, the bill doesn't go far enough. But what I wish to talk about today is perhaps a problem that is going to be coming to us in this regard down the track. Now that we have entered into multiple, the Japanese Australia Free Trade Agreement, the Korean Australian Free Trade Agreement, and of course the China Free Trade Agreement, and I will not necessarily incorporate the Trans-Pacific Partnership in this because I'm not familiar really with the labour movement of people provisions within that document. But I can certainly, and the comments I make, I think particularly, will be relevant to an issue that I can anticipate and other people are anticipating will rise from the CAFTA and the CHAFTA agreements. And these are in particular in relation to the provisions within those documents that relate to the supply of contractual services. So we know that there are an ever-expanding range of occupations, certainly not just managerial professional, but really now a very broadly defined range of technical skills that are caught within these free trade agreements for which there is very explicitly no labour market testing. So we're talking about, I'm not talking at this point necessarily about those things that are subject to the IFAs, because we did get some modest labour market testing requirements incorporated into that, but into those substantial provisions of CAFTA and CHAFTA where indeed there are no labour market testing, and it may indeed be even with the IFAs because the provisions for labour market testing have been so modest. And this arises around the sale of jobs. Now, the legislation that we are contemplating makes it illegal for people within Australia to engage in conduct that you might describe as selling a job. And I have looked at and there is some capacity for there to be some extraterritorial application of this legislation, both in terms of both the criminal and the civil provisions, but they are constrained. And so the real bulk of where we are going to see this problem emerge, in my view, is not going to be captured at all by this legislation. Now, talking to people that routinely do business in China, there are very, very many jobs that are for sale. That if, for example, you wanted to get a job at the Shanghai port, it is required, I'm not necessarily talking about the senior executive positions, but one pays someone for that job. And this is repeated, as I understand it, in very many areas within China. And indeed, very often when, as we know, as I've personally witnessed throughout Southeast Asia, when there are many Chinese projects where they bring in their own workforce, their entire construction programs, for example, in East Timor, all of the Chinese aid projects that came in, building the presidential palace and building the foreign affairs departments, totally involved a Chinese workforce. Now, it is very possible, and I'm not making the allegation in respect to those particular projects, but one would be naive to think that there would not be in areas the sale of these jobs, that people obviously very desperate and very keen to get the opportunities of working in Australia for Australian wages would be prepared to pay an agent or a prospective employer for the opportunity to take on that job. And as far as I can see within, and even looking at those provisions that give some extended extraterritorial reach, we are not going to be in this legislation able to necessarily prosecute this sort of conduct. So it goes, and as I say, can you imagine? We've got a project that is going to be developed by a Chinese company, a company that is resident and registered in China. They or certain executives perhaps of that firm engage in conduct that would see those jobs effectively being sold, the jobs that involve coming to Australia and delivering the project in Australia, those jobs, that opportunity being a very marketable asset, being sold. Now, when I look at this, and I would very much appreciate if I note the Minister's advisors there, and I would be very interested to see, and I would hope I've got this wrong, but when I look at this provision, I look at the extraterritorial provisions, those companies would not be able to be prosecuted in Australia, they would not be able to be fined. Now, I think we could deal with this. We could deal with this insofar as making an amendment perhaps to the Migration Act, that if you're bringing people in under contractual services, that there does need to be some requirement for them to be registered in some way within Australia, so that these provisions, the reach of this protective legislation is available. Now, I don't want to become overwrought about this particular problem, but I understand from reading the literature around on these cases, and I have no capacity to judge whether or not they are a fair and reasonable assessment of the case, but that this is something that is going on, and that we are seeing around the world something that is almost approximating a system of indentured labour. So a person buys a job, they or their family then become obligated in their home country to pay either the employer, who is being a foreign national, is not necessarily captured by this legislation, or who is a third-party provider and are not captured by this in a foreign country, not captured by this legislation. They are required to, indeed, over a period of many years, pay off a debt that is incurred by virtue of them entering into this employment opportunity in Australia. And there are some that say that we risk, in fact, going back to a situation that was endemic throughout Southeast Asia and indeed for some time in Australia, of indentured labour. And again, I don't want to be overwrought about this, because I don't have, I do need clarification on this extraterritorial reach, but I do think we need to flag this as a problem. We need to flag this as a problem that arises out of the fact that now the 457 visas that will be granted for the contractual services, and indeed possibly even the IFA, may become assets to be sold in another country by people desperate to make a better life for themselves, understandably wanting to take this opportunity. And we view this as these workers being paid the equivalent of Australian workers, and that's very important. But we cannot guarantee to what extent they may, in their home country, in fact have a big debt bond that will be required to be paid by them or by their families. So I just want to flag that as something that I think is an issue that we're going to have to deal with, we're going to have to grapple with over the next couple of years, because it will be a serious issue for us. I think there is a great naivety that is often said by proponents who say that, well, why would these foreign employers want to bring in their own workforce when they can employ Australians? They don't have to fly them over. Well, as I say, we know that at least in part of that answer is that there is the capacity to actually benefit from the sale of the job. So it is not the worker that is necessarily getting the benefit, but indeed the proponent, or it might be people acting illegally within the proponent, but nevertheless are getting the benefit of selling these jobs and really undermining the protection that this legislation purports to give us. So with those comments, I will leave it, but I just say I think that we need to have a much greater watching brief on how the importation of overseas workers occurs under these new free trade agreements. Thank you.